Number 48, Annie E. Harper et al. Appellants versus Virginia State Board of Elections et al.
Harper versus Virginia State Board of Elections is a Supreme Court decision about voting. It was an equal protection case. When we think about equal protection, we tend to think about the varying levels of scrutiny that courts use to evaluate equal protection claims. If you qualify for one of the heightened levels of scrutiny, strict scrutiny or intermediate scrutiny, then the pressure is really on the government to show a good justification for what it's doing. So getting the higher levels of scrutiny is a big deal, and there are two basic ways you can get the higher levels of scrutiny. One is to show that the government is treating people differently based on a suspect or quasi-suspect characteristic, like race or gender. But the other way to get heightened scrutiny under the Equal Protection Clause is to show that the government is treating people differently with respect to something that is regarded as a fundamental right or fundamental interest. In other words, strict scrutiny might apply even if it doesn't have anything to do with race or gender or any other characteristic like that receives special protection. Strict scrutiny might apply, nevertheless, if you can show the government is discriminating against you with respect to some activity that is considered to be especially important and deserving of enhanced constitutional protection. Voting is one of those things. It's a fundamental interest under the Equal Protection Clause.
Voting is such an important affair that there is quite a bit of formality connected with it.
The right to vote has been specifically addressed by a lot of the Constitution's amendments over the years. Many of the amendments have expanded the right to vote. For example, the 15th Amendment gave the right to vote to people of all races. The 19th Amendment guaranteed women the right to vote. The 26th Amendment lowered the voting age to 18 years old. But sometimes there will be issues relating to voting that aren't covered by those specific provisions, and so people will bring their claims under the Equal Protection Clause. And they'll argue that strict scrutiny should apply, again, even if there's not racial or gender discrimination or something like that, simply because voting is such an important fundamental interest. The Harper case arose in Virginia, where the state charged a fee to vote. The cost was $1.50. Just to put this in perspective, if you adjusted it for inflation, it would be the equivalent to a tax or fee of about $10 today. Now, the issue of poll taxes had already been addressed by a constitutional amendment. The 24th Amendment had been added to the Constitution in 1964, and it did away with poll taxes for federal elections, but it didn't prohibit them for state elections. And so the issue in Harper for the Supreme Court was whether a state could continue to have poll taxes for its state elections or whether that would violate the Constitution. The Supreme Court, by a vote of 6-3, decided that the Virginia poll tax did violate the Equal Protection Clause of the Constitution. There were 3 dissenters. One was Justice Hugo Black, and his dissent is quite consistent with his overall approach to law. He likes things to be as clear and explicit and absolute as possible. He was not comfortable with judges being able to pick and choose what rights they were going to treat as more important than others. He liked things to be spelled out clearly in the Constitution, and he didn't feel there was anything there that prohibited a poll tax. There was also a dissent by John Marshall Harlan and Potter Stewart, and they basically emphasized the importance of tradition, the notion that these sorts of poll taxes had been around for many years. And they argued that the framers of the Constitution weren't extremely egalitarian or purely democratic. They were a bunch of pretty aristocratic people, and they were very comfortable with the notion that there would be an elite class of people who deserved the greatest say in running things politically. According to this dissent, the framers of the Constitution thought that too much democracy could be a dangerous thing. If the government did whatever a bare majority of the people supported at a particular time, you could have chaos. It could be like mob rule. Instead, the founders of the United States deliberately chose a more Republican form of government, not a pure democracy. Now that's Republican with a lowercase r, meaning not the Republican Party, but a form of government in which the majority rule doesn't always prevail. Just because 51% of the people want to do something at a particular time, it doesn't mean it will happen. The majority's will is restrained by the Constitution. It's also restrained by having power divided. It's divided between the different levels of government, the state and federal and local, and it's divided between the different branches of government. And hopefully the majority's will also be restrained, in some instances, by the fact that the leaders who get elected will be very wise, sophisticated people who won't always do whatever the majority of the population wants them to do if it's not a good idea. So in other words, these dissenters think that we shouldn't get too carried away today with notions of egalitarianism or an equal ability for everybody to participate in the political process. But the majority of the Supreme Court felt otherwise. They felt that your financial ability to be able to pay a poll tax doesn't really have any appropriate bearing on whether or not you should be able to vote. And therefore, charging a fee for voting violated people's fundamental interest in being able to participate in the political process. The Harper decision illustrates the importance of strict scrutiny. Virginia's poll tax would almost certainly have been upheld if you applied just a weak form of rational basis scrutiny, because elections cost money, and the poll tax would be a rational way of covering those costs. But strict scrutiny applied because voting is a fundamental interest, and so the law was struck down.